Hi, I hope you can all hear me. Hello. If people, yes, thank you. So, welcome to this next panel. It is about aligning cybersecurity information sharing with the EU data protection framework. And this is a panel organized by TILT, so the Tilburg Institute for Law, Technology and Society. And we'll be talking about quite a niche topic, but again, it also has a much broader reflections on cybersecurity and data protection as well. So cybersecurity information sharing is widely recognized as essential for the prevention, detection of cybersecurity threats and vulnerabilities and incidents, and therefore essential for strengthening the overall level of cybersecurity. It's increasingly encouraged and even mandated by law as well. However, due to a variety of perceived obstacles, the cybersecurity information sharing arrangements do not always unlock their full potential. And data protection is one of these often mentioned barriers to cybersecurity information sharing. For instance, in DORA, that is the Digital Operational Resilience Act, so that does cybersecurity for banks. Even though DORA stresses the importance of cybersecurity information sharing, it also states that the uncertainty about compatibility with EU data protection rules is one of the key factors inhibiting such intelligence sharing. Little to no explanation is provided on how such data protection rules actually pose a barrier to cybersecurity information sharing, or what level of privacy intrusiveness or data protection risks actually arise in this space. So that is what we will be investigating today. To what extent does data protection pose a barrier to cybersecurity information sharing, and how can it be done in accordance with EU data protection law? And to do so, I am very lucky to have some great speakers to help shed light on this issue. First of all, we have Renate from ENISA, who will be joining us online and will help illuminate the practical and technical landscape of cybersecurity information sharing. Next, we have Niovi Vavula from the University of Luxembourg, where she's an associate professor and holds the chair in cyber policy. We also have Pier Giorgio Chiara, an assistant professor at the University of Bologna. And finally, we will hear from Locke Morel, who is senior counsel at Morrison Forrester, the professor of global ICT law at Tilburg University, and a member of the Dutch Cybersecurity Council. The panelists will give a brief opening remark, and then we'll open the floor for questions and discussions. So without much further ado, I now give the floor to Renate.
For organizing this panel and moderating this panel. And thank you also, Locke here and session. Like Suzanne said, it may be a niche perspective, but I think the topic is super hot. From the EU Agency of Cybersecurity, where I am working, we are also very much working on this topic. I will explain you more a bit later in my short introduction why we are working so heavily on this topic. But let me start first by saying that, of course, when we talk about data protection and cybersecurity and how they interrelate with each other, that, of course, first of all, when we face the challenges of information sharing and reporting incidents or reporting vulnerabilities, of course, Article 5.1, Section F of GDPR is indicating that cybersecurity actually is one of the main principles when it comes to data protection. So it relates to the fact that it is important to ensure the appropriate security, including the protection against accidental loss, the destruction or damage, or using appropriate technical and organizational measures. So it focuses on integrity and the confidentiality of the data. Furthermore, Article 32.1, Section 8 to D of GDPR is of course also clear in what kind of rules we need to have in place in order to ensure data protection. It starts with the use of encryption, ensuring ongoing confidentiality, integrity, availability, and resilience, the ability to restore the availability and the access to personal data in the event of an incident, and of course, obligation to do regular testing, making assessments, and evaluating the effectiveness of the security measures that need to be in place. So first of all, the interesting concept is that although there may be a lot of EU regulation when it comes to cybersecurity, and you face the challenges when exchanging information when it comes to incidents and vulnerability handling, and all kinds of authorities, groups, and actors that are involved in this exchange of information, it is, of course, of primary interest to know that it is actually an obligation to do this. And this obligation does not only arrive from the EU cybersecurity laws that currently are there. No, it's a principle in GDPR. And it's, of course, an important article also that needs to ensure the protection of the data, like Article 32. So I have to say that as well, more or less a real nerd in cybersecurity and a true passion having for that, there is, of course, a little bit of a paradox in these two important articles of GDPR. Because if you want to ensure all these obligations, indeed, this leads to an increase of processing of personal data. Because if you want to prevent that incidents are happening, you want to detect them and you want to respond to them, of course, you need to a certain extent have access to the data to understand what is happening and to make sure that you have the, of course, mitigating measures in place to reduce the damage, the loss, or destruction of the data at hand. So in that respect, also the topic of this let's say panel session is also a little bit intriguing and super interesting to see how these legal obligations that are, of course, under EU law, all of a sudden become a question. Wait a minute, if we share all this data with all these EU laws and all these parties and actors that are involved, do they actually take into consideration GDPR? And then, of course, the circle is round, because why do they take these information sharing and obligations into account? Because it started all with Article 32. When GDPR was implemented, cybersecurity, of course, was still a rising topic. Um, Together with it, also a lot of cybersecurity incidents skyrocketed from that year on. It was also clear that looking at the article, that Article 32 only and the principle referenced in Article 5.1 Section F, of course, was not enough to make sure that the data is really well protected. This was one of the reasons why the European Commission started to enhance cybersecurity law and to also implement cybersecurity law. Now, briefly touching upon these laws that are in place, there are quite a few. There is the critical entity resilience regulation. There is the NIS2 direction. There is the directive. There is the Cyber Resilience Act. There is the AI Act. There is the Cybersecurity Act, the Cyber Solidarity Act, the EIDAS 2 directive. So there are a lot of regulations that all are focusing on cybersecurity, and that indeed also focus with the respective articles they have on exchange of data, on reporting incidents, on reporting vulnerabilities, and to process all these, and to process and act upon all this information sharing.
looking at the different actors that are involved in all these regulations, you see a plethora of authorities, different authorities. You see also that actors are legally obligated to share with public institutions, authorities, and EU institutions their information. Supply chain is also obligated to share information to ensure that whatever happens is reaching the right actors in order to report incidents or vulnerabilities that occur. And then, of course, you have not only the sharing of information within the public domain, but also the sharing of information between the public and the private domain, where industry and public are more or less working together in sharing information in order to prevent worst case scenarios when an incident or a vulnerability is not addressed soon enough. Also, like the Suzanne already indicated, also from law enforcement perspective, of course, a lot of parties do investigations, also leading to information sharing, leading to the main principles of cybersecurity to act upon prevention, detection, and response. So super interesting to have in this panel our dear colleagues. But when it comes to the incident response, what information is actually shared? Does it need access to personal data, or is it more or less related to exchange of technical information that helps us to understand what the incident is about and how to address and prevent and respond to this incident? Next to that, we also have an important role in incident reporting. Now, reporting of the incident is also related to the analysis of a technical IT system. Sharing of information in this respect is not necessarily related to access to personal data related to the specific incident. It is more a technical analysis and sharing of information. Now, next to that, we also have a more aggregated level of cybersecurity reporting. That means that based upon incidents that happened in certain member states, these member states report
You're frozen, but we're also running towards the end of your allotted time. So I will.
based upon the information that is shared.
Did that come through?
My remark that a lot of different actors are involved, a lot of challenges are on the road, but sharing this information is not necessarily, in my view, a real risk to data protection.
Renate, for your contribution and for highlighting both this complementarity and the paradox between data protection and cybersecurity, and questioning if it's even a risk. I will now quickly give the floor to Niovi.
Thank you so much. If my slides could be pulled up, I would be very grateful. So my presentation is going to follow very nicely from Renate's presentation, because I will focus mostly on the information sharing and exchange possibilities via the NIS2 directive. And it is true that in implementing cybersecurity, there are possible risks to personal data protection, and looking into those possibilities of information sharing could be enlightening as to what challenges for personal data protection exist. I will not focus so much on the legal basis for processing of personal data. There is quite a lot of literature emerging about the existence of a legal obligation to process personal data, but more on the information sharing among the critical infrastructure entities, essential and important entities, as well as competent authorities, the single points of contacts, the cybersecurity incident response teams, as well as other authorities, particularly law enforcement. So basically, what emerges from the NIS2 directive as a first comment is that there is an increased specification of information sharing requirements and more references to data protection, specifically the GDPR, compared to the NIS directive. However, at the same time, it's also evident that there is a lot of discretionary power offered to the member states when implementing the directive. And I will explain various points where we see that this discretion of member states exists. One point has to do with the specification of a policy framework on information sharing in the national cybersecurity strategy. So the NIS2 directive requires member states to develop a national cybersecurity strategy. This existed also in the NIS directive, but now it requires the creation of a policy framework. So this already hints towards the fact that it's actually up to the member states to regulate how the information sharing should take place, and that would include different on the risks, on the cyber threats, on the incidents. I hear what Renate says, that this may not always involve personal data, and in principle it may not involve, but when there is a possibility of exchange of information on victims or users who have been affected, or on threat actors, then the possibility of exchange of information on personal data should not be excluded. And this is indeed also reflected in Article 214 of the NIS2 directive, which explains that the competent authorities, the single points of contacts, and the cybersecurity incident response teams must process personal data, and this must be in line with the GDPR. And this basically, the problem lies in the fact that if we go into the recitals of the NIS2 directive, we shall see that also it's up to the national law to consider how to do that. So what about specifically the information sharing between the cybersecurity incident response team? There we have a little bit more specification about the possibilities of information sharing. This should be done not only with the essential and important entities, but other also relevant stakeholders, without specifying which stakeholders this should be. And the most important issue is that it also creates possibilities for cooperation partnerships with teams in third countries, including the effective, efficient, and secure information exchange. And here there is an explicit mention that this can include the exchange of personal data in accordance with EU data protection law, which means that, again, GDPR applies. We need to see whether there is an adequacy decision, whether there are appropriate safeguards, or whether there are any other exceptions that apply. The interesting thing is that if this is considered also to be a criminal offense, maybe there is a possibility of applying an exception on public security, especially if cybersecurity is considered as a public interest, and therefore there is more and more possibilities for exchanges of personal data between the teams in different countries. So the more it is an incident to be considered as a criminal offense, the easier it would be to justify also transfers of data, personal data, to third countries. The NIS2 directive doesn't only allow the mandatory exchange of information between competent authorities, but also it creates voluntary schemes of information exchange between the critical infrastructure entities, as well as entities which do not fall within the scope of the directive. So again, it is up to the national discretionary power to determine how this will be done, but this is also should be possible. And here it also becomes clear that it can involve personal data, because among the aspects to be shared, it's threat actor specific information. So there we can see the link with personal data again. The last point to finish my intervention has to do with the possibility of other authorities, not directly regulated by the NIS2 directive, receiving information on incidents. And here, Article 13.4 of the NIS2 directive is very important, because it also mandates that member states must, to the extent possible, ensure appropriate cooperation between the authorities that are regulated regulated under the NIS2 directive with, among others, law enforcement authorities. Problem is that, again, there is a lot of discretionary power. So we must see how the NIS2 directive will be implemented, to see how this is regulated. Problem is, again, most of the countries, according to latest information, have not implemented the NIS2 directive. I have checked a couple of implementations. For instance, in the Greek implementation, I didn't see anything on that front. We could get a little bit more of guidance on the framework decision of 2013, 40 of 2013, which is regulating attacks on information systems from a criminal law perspective. But again, if we see Article 13, it doesn't say much on that. It provides a timeline for exchanges of information among competent authorities within the member states on addressing cybercrime events. The problem is, again, that there is no linkage between the two legal instruments. And again, there is a gap which can become even greater as a gap if we think of potential exchanges of data with intelligence services. And there we can enter an area where also there are supervision problems, audit problems as regards the use of such data. So I will finish my presentation here. The only thing that I want to say as a last point is that coming from a law enforcement angle, we can see a lot of parallels on the lack of regulatory requirements or the difficulties in regulating this field, as it has been also with the passenger information units, so in the PNR sector, in the money laundering sector with FIUs. So we see a progressive intensification of information sharing obligations. The rules are still a little bit loose. There are some principles, but the rules are a bit loose on the kinds of data, on the retention period, on the use of the data. So I say that the more information sharing should take place, the more regulation is needed. So thank you so much for your attention.
Thank you, Niovi. I will now give the floor to Pier Giorgio Chiara.
Thank you, Suzanne. Maybe this isn't working. I don't know. Yeah, maybe. I will try with this. Yeah, thank you. I have a slide presentation too. Meanwhile, I just wanted to say that my introductory speech will try to, thank you, try to navigate through the guiding questions of the panel. And I will start with the first one, namely, how does the European cybersecurity legislative framework mandate the sharing of relevant cybersecurity information? Niovi already covered the NIS2 directive, so I will jump to the CRA and the Cyber Solidarity Act. Before that, I will open by saying that recently adopted legislation in the field of cybersecurity mandate the sharing of information, albeit at different levels. So by keeping an extensive interpretation of cybersecurity information sharing, that is not only for example, Article 29 of the NIS2 directive foreseeing voluntary cybersecurity information sharing arrangements between NIS2 entities, but also including coordinated vulnerability disclosure or incident notification. The CRA mandates several rules regarding cybersecurity-related information disclosure. For example, manufacturers must notify CSIRT and ENISA of any actively vulnerability discovered or severe incident affecting the security of the product. ENISA might submit to EU Cyclone, if relevant, such information, as well as the CSIRT, national CSIRT, may inform the public, again, if relevant. Again, on the point of manufacturers, those actors have to take measures, implement measures to facilitate the sharing of information about potential vulnerabilities affecting the products or third-party components integrated in the products. And open source software stewards must implement policies that inter alia should promote sharing information regarding discovered vulnerabilities. Finally, with regard to the Cyber Solidarity Act, the newcomer in EU cybersecurity law, within the mechanism of the European Cybersecurity Alert System, which, by the way, is voluntary. This aims to strengthen the information sharing between public and private entities and supports the exchange of relevant information with sectoral and cross-sectoral communities. The more public and private stakeholders share relevant cybersecurity information, the higher the level of cybersecurity of the whole ecosystem will achieve. At the same time, data protection law might constrain the cybersecurity information sharing arrangement practices. Furthermore, or to make things worse, cybersecurity information sharing might entail several data protection risks, and in particular, I will limit my discussion to 3. The first risk relates to unlawful processing. Sharing cybersecurity information often require, as we already anticipated by the other speakers, the processing of specific categories of personal data, namely URLs, IP addresses, domain names, and data controllers, therefore, must rely on the appropriate legal basis under not only the GDPR, but also the Law Enforcement Directive or the UDPR where applicable, especially in the context of information sharing carried out by institutions with different focuses. Second, and related to that, EU data protection law requires data be collected and processed for specified, explicit, and legitimate purposes, and excessive data sharing in the context of cybersecurity information sharing might breach data minimization principle. Thirdly, inadequate anonymization practices might mislead data controllers into thinking they're processing non-personal data. And related to that, well, actually not related to that, but in addition to that, pseudonymization, in light of the SRB versus EDPS case before the Court of Justice, might play a difficult role, as we should also be asking what personal data is. Practitioners are not wrong when stating that anonymization and pseudonymization can render the cyber threat intelligence virtually useless, as encryption is used for cyber threat intelligence. Pseudonymization might be irrelevant to achieving the goals of information security sharing, as for example, in the case of spear phishing emails, most interesting data is in plain, and this data is very likely to be personal. Besides compliance risks, information sharing also entail information security risks, such as data leaks or mishandling or misuse of data, which may not be personal data, thus falling in scope of the GDPR. And to address the above-mentioned risks, data controllers must consider appropriate and proportionate technical and organizational measures, such as delay data as soon as they are no longer necessary for the intended use, that is, cybersecurity information sharing. From an organizational viewpoint, decentralized models of information sharing, such as peer-to-peer architectures, eliminate the problem of having a single point of failure, such as in the centralized model, which is adopted by the EU legislator, and also makes and enable agility as participants receive relevant information directly from the source. On the other hand, centralized models are the most effective way to build trust between participants. From a technical perspective, instead, future information sharing arrangements can consider relying on zero trust frameworks, operating on the principle of never trust, always verify, to mitigate the risk of data leaks, for example. Zero trust frameworks combine several security measures such as continuous authentication, least privilege access, breach assumption, automated threat detection, assuming all network traffic devices, processes are malicious and untrustworthy. And these last security measures, namely cryptography or encryption, brings me to my last point, namely, still related on technical measures, homomorphic encryption allows the data to be processed without decrypting it, ensuring confidentiality while still enabling collaborative analysis and threat intelligence sharing. Thus, it may prove to be particularly helpful in the context of such arrangements. Thank you.
Thank you, Pier Giorgio. And last but not least, Locke.
Thank you. I'll wait for my slides to pop up. Hi, Renate. Nice to see you again. I will follow Renate's starting point quite closely. So let's have a look. What are the real issues? The European Court says IP addresses are often personal data. The question is, can they qualify as criminal data? And if so, when? What is the legal basis to share with other parties? And then I have with the ENISA, the CSIRTs, the NSCs, the National Cybersecurity Centers of the different member states, law enforcement. Then you have private-to-private sharing in an ISAC, information sharing between I don't know, all the universities. And then you have information sharing with victims, and sometimes that needs to take place via their telcos or ISPs because you don't know their actual identity. And then the question is, and that's what we just heard, NIS2 and DORA, do they provide sufficient legal basis? Some of it is mandatory, the other is voluntary. I just want to flag for the GDPR. GDPR doesn't make it mandatory to share anything. Mostly it is either a legal basis to do so, but that doesn't mean you need to do it. The mandatory and voluntary sharing is more about not so much personal data, but they want you to share the data. It is not about providing a legal basis on the GDPR for it to be possible. Do you understand the difference? Anyway, I have a complete different perspective as often, and that is also because I'm heavily involved in this type of project. So let's have a look at what is happening. You have an attacker, you have a victim whose devices are taken under control of the attacker because of they placed malware on your devices, and it interoperates as a result for, I don't know, being used for a DDoS attack. And then if you're an organization and you are attacked and you want to investigate, you have the employees in your organization, and maybe the forensic analysis require you to do some investigation. So we have three groups of, so let's have a look. We just heard URLs, IP, etc. For me, it's all a bit the same, but let's see, we have a threat actor IP address that links to the IT infrastructure used by the threat actor to try to get a whole army of infected devices. The main server used is the command and control server. And I gave the definition, but it is used, that CNC or C2 server is used to attack by attackers to distribute and control malware on infected devices. They allow then, to execute commands. And once a device is infected, it sends a signal back to the host server, allowing the attacker to control the infected device. It's a bit similar as if you ask your support department to do things for you, to fix your problem. I hope you see that this IP address of the CNC server do you think that actually leads to an individual? Or do you think the attackers use, I don't know, 1,000 ways to hide their identity? I tell you, in practice, in 0 cases, it really leads back to an individual, let alone a criminal group. They hide it. So for me, this is not personal data, yeah? Then we have the IP addresses of the infected devices, and those are often, that's the victims, eh? It's often a consumer. And then it concerns an address of a telco or an ISP, like KPN, Ziggo, because nobody except KPN or the Ziggo knows which consumer is behind that address. Yeah? So where does all these privacy issues come from? And I'll explain later what I think the legal bases are. But for instance, in the Netherlands, and I'm heavily involved there because I'm on the Cybersecurity Council, just imagine you're the Dutch National Cybersecurity Center and you get daily thousands of IP addresses from shadow server who monitor the internet, IP addresses from CNC servers and those of the infected devices, the victims. So you have different types of information sharing. Eh? It's a cyber threat intel sharing between the NCSC and, I don't know, critical infrastructure, the CSIRTs of, I don't know, the healthcare, the universities. And they say, well, the IP address of the attackers, you can share them with and within ISACs. So interesting, including the IP addresses of the infected devices, including personal data. And then they said, victim notification, yeah, the victim information couldn't be shared with a third-party KPN because they are a third party. May only be shared with the victim itself because it's personal data. But the NCSC cannot find the address of the individual. I hope you see that the privacy, the sharing of one is far more invasive because that includes then number 2. I want to explain, but you know, my door is open. And then I cannot inform the individual whose door is open because of the privacy of the person whose door is open. Are we all having it? What purpose is GDPR? It is about ensuring, you know, privacy secure. Anyway, so this is a difficult one, and I told them 1,000 times, and then they changed the law now to allow this as well. Yeah? So, but is that a real issue? No, of course it could have happened on the GDPR. It's a legitimate interest, especially in case in the interest of the individual to share this. In my opinion, the real privacy issue is the one flagged by NIST. That's the US Information Security Technology Institute, and they give specific guide to cyber threat information sharing. Yeah, that is really information that helps you to prevent further attacks or remedy your own infiltration. So their definition is any information that can help an organization to identify, assess, monitor, and respond to cyber threats. So what are the indicators? URLs, the security alerts, the TTPs, yeah? That is information you collect internally already to find out that you're infiltrated to start with. And the key challenge then is that internally, the forensics are starting to look into the hard drives of certain employees to review the malware, to review emails that you clicked on. What is the phishing email to start with? That is a legitimate interest. Everybody agrees that that is allowed to do. And then the question is, you should limit that as much as you can and limit the people who can do that. That is done in any company. And then NIST says, look, if you then start sharing that intel with somebody else to also help them protect themselves, then you need to scrub all non-relevant PII, that it is that individual, blah, 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 and focus on the exchange of the indicators, the IP address, the URLs, etc. And that is mostly free of PII, such as file hashes, network port numbers, registry key values. Here again, focus, the recommendation is focus on the destination IP addresses, etc., etc. And then the rest you need to anonymize as much. And then if you send it, encrypt it in transit. So go back to the issue. The court says IP addresses often qualify as personal data, and that is also for dynamic IP addresses if they're registered with a telco because they have the information to relate it back to the individual. Fair enough. Criminal data. Well, the Dutch court said, look, it can't be just a loose element. You need the data should in and of itself basically constitute enough proof for a crime. A reasonable suspicion shouldn't be enough. What do you think? A single IP address, is that then criminal data? You don't even know whether it's the attacker or a victim, actually. It doesn't prove anything. It is an indicator for further investigation. So the idea that an IP address could constitute criminal data is bizarre. Then the next one is, to get it all out of the way, the new amended NIS2 implementation law now sets out, look, an IP address is not criminal data. Okay. I find it difficult to argue in the privacy community, oh, it's cyber, so it is criminal data, so we need to apply, instead of going back what is actually happening. Because I don't know whether you realize, but a lot of times privacy is considered an obstacle to totally intuitive things we should do in society to protect ourselves. And look, I'm in favor of privacy, but not, general discussions about what is what. So let's have a look. The attacker IP address, I think, is not personal data. It's certainly not criminal data, and the GDPR doesn't apply. And the EDPB guidelines on e-privacy directive also says, look, an IP address is only personal data if it is related to the actual one, the individual. So there's also ample suggestion in the guidelines that that is the correct interpretation. Then we have the victim IP address. That is personal data. Is not criminal data, for sure. They are not even criminals. They are the victims. So cyber threat intel sharing is in the interest of the individual. I tell you, you have a legitimate interest. And if you need to share it, fine, but we're talking about GDPR where you have a legal basis. And the victim notification, sure, you have a legitimate interest. Then you have the employee data. That is for sure personal data. I think it's not relevant for CTI sharing and also not for victim notification. So that is where we should do a good check that you do not unnecessarily share personal data. And the interesting part is everybody does that already, because why would you expose your individual employees and their email boxes to this type? So the threat here and the impact is zero. We're making a thing out of nothing. I just want to, and all the things about, and the mandatory sharing is true, but that is about the fact GDPR never obliges you to share. It is about facilitating sharing with guardrails, like under the employee data thing. What they are talking about, or the mandatory things in the vol, is making sure there are platforms where you can do it in a confidential way. It is making sure that type of intel is shared and not they sit on it and think, well, I covered my ass with my solutions. They want to protect the rest of society. It has nothing to do with privacy. So sorry to go on a bit, but I find it difficult to swallow that as a community, we do not really know what it is, and then still have an opinion. Thank you.
Thank you for your contribution. We will now open the floor for questions. Unfortunately, there's no mic to go around, so there's a mic up front here. So if you have any questions or reflections for the panelists, please come up here. Or say it very, very loudly, and then we can repeat it into the mic. Yeah. So, any questions?
Can you take down the slides so we can see? Yeah, thank you.
Is it working? Yeah, hello. Jeroen de Wijn from SURF. Hi, we've met. One question, looking all this reactive sharing and the reactive looking at stuff. What I'm finding in the practice that a lot of discussion in the cybersecurity is about the preventive, so the algorithms, the predictive algorithms, and then what would be decision making, and is it automatic decision making? So it's not just sharing, but also acting on it in an automated way, profiling maybe even. What is the demarcation between the privacy rules and the interest of society basically in this?
Yeah, it would be blocking certain IP addresses because you think blah, blah, blah. Yeah.
Yeah, but it can be further with modern SIEM systems that they are analyzing patterns of people who are surfing and maybe taking action, or at the very least alerting. So you're basically profiling and maybe even this automated decision
profiling
making.
for what? For an attacker
Yeah,
in a pattern?
malicious intent.
Yeah. Again, is it personal data? If it is a machine network where you can't ever relate it back to an individual, and the interesting part is, I don't want to, but if you block those, I see it when they actually take down the web shops that are apparently, you get very few complaints. These are criminals.
Yeah, yeah. No, the
I'm happy if there's a mistake, they could stand up and you could say, okay, we release it, but they never complain.
No, the problem is the false positives and the people who are worried about that. Maybe you have an idea about that, because.
Yeah, thank you for the question. I think it's they are the case here because the tendency is to amass vast quantity of data just to be prepared and to build, as you said, the profile to understand better the threat landscape and mitigate the risk of attacks. On the other hand, such information, albeit might seem non-personal, might in fact reveal patterns or private information and might be considered personal. I say might because in the Breyer era, the personal data, the concept of personal data was quite broad. And now, pending this SRB versus a DPS case, we are witnessing possibly a massive paradigm shift in data protection law that might, almost destroying what we knew about data protection law. I do think that,
Is that true? No, I'm in the sense, the case is about somebody having the key, but not the one getting it. But here, with an attacker, nobody has the key.
Yeah, no, indeed. I think,
okay.
I think that the point is where do we stand between the absolutist approach and the relativist approach? So, do we have to take a side to categorize data as personal or non-personal? So, for example, the perspective of the recipient of data, or do we have to consider all the theoretical possibilities to possibly re-identify an individual to consider that data personal or not?
Yeah. But let's take the restricted approach. So let's say it doesn't matter whether you can keep the key or you can't access the key, but then what would you do with this attacker? How are you going to? Nobody has the key. So I'm failing to understand why this potential case of the EDPS would make a difference.
No, I see your point.
Yeah?
So I am too not very. I don't have a particularly strong opinion on that. As both position have their own merits. Because, of course, if let's say encryption algorithms are particularly strong and you don't have keys to decipher such a certain set of data, it is true that technically those data are non-personal to you because you cannot re-identify or identify an individual. And that I see the merit of the relativist approach. That's one that has been taken by the tribunal of the EU. On the other hand, adopting the relativist approach, generalizing the relativist approach, might have unintended consequences. For example, in the cloud computing, in a cloud computing setting, a powerful actor, usually US-based, can claim that all the data is hosting because it's encrypted and end-to-end encrypted. So the provider does not have the key. So technically cannot see the information in plain text. Can claim that such data is non-personal, that is, the GDPR does not apply, that is, the guarantees, the set of protection of the GDPR does not apply. So I'm very curious to see how this legal dispute will eventually end, because it can change a lot or it cannot. It will not change anything. But again, in the context of cyber threat intelligence, and I will finish here, also a particularly interesting and crucial issue is the one of the legal basis, as you raised, because of course legitimate interest has the lion's share, I guess, in terms of the choice of controllers. But you have to perform a legitimate interest assessment. And after the Meta case, what's have been cleared up by the Court of Justice is that these bases must be intended restrictively. So it might be useful also to reason on possibly other legal bases, for example, the public interest or compliance to, let's say, legal obligation. Of course, it's very difficult that private stakeholders sharing among themselves information can rely on these two latter bases. I guess they will and they can rely on legitimate interest, but in case of incident notification, they can rely on Article 6, Paragraph 1, letter C of the GDPR, on the legal obligation. And yeah, so I will not take any longer. Thank you.
Thank you so much. Niovi or Renate, do you have anything as well to respond to this question? Otherwise, we can move on to the next question.
No, anything I would say would be more on whether public interest should be considered as a legal basis. And okay. I think that, yes, so sorry. So yeah, I fully agree with that the interpretation of how we understand encryption as qualifying or declassifying data as personal data is particularly interesting and important because it may lead to downgrading the protection of personal data. And I think that these dangers should be highlighted, should be considered. I've also fully agree that legitimate interest, whilst is the legal basis primarily used, I also see value in, we see increasing reliance also on legal obligation because there are mandatory requirements under the legal framework, despite the voluntary sharing, but also there is quite a lot of discussion as to whether cybersecurity ultimately is in the public interest. And I think that the less niche this field becomes, the more it is regulated, the more it is a priority, strategic a priority, the more we should rely also on public interest. So I would say that this would be the future.
Hello, Juraj Seifert from European Commission and Vrije Universiteit Brussels as well. I have a question for the last speaker. I just wanted to ask you if you could clarify certain concepts that you presented. So I was wondering, how do you define criminal data? You were using a lot of the term criminal data. Just wondering, what does that actually mean? And then also, what are the consequences for the context about which everyone here is discussing, if something is labeled as criminal data as opposed to if it's not criminal data? Thank you. Okay.
Well, criminal data is if you're convicted of a crime and it sits in a registry as a offender registry, things like that. That is for sure criminal data. And then there's a gray area of what could qualify ultimately as criminal data. And that our Supreme Court in the Netherlands, for instance, had to answer that question. And they said, look, it should be reflecting facts that together constitute a criminal offense under the criminal code. And a reasonable suspicion is not enough. It needs to be more. Well, if you have one data element, which is in the case of the threat intel sharing is always about an IP address that is sending commands, or IP addresses or URLs of servers, or anyway, so it is one element, but it requires a lot of investigation and further facts, and in most cases the police, if they want to take an IP address of a command and of a C2 server, to figure out who is behind it, because it is a whole pattern then of I don't know, where they use providers, and there's always 1,000 steps behind it that you couldn't even go to an ISP and ask for the identity or the address. Do you see? So that element in and of itself, though, if you use it and you start investigating, you could ultimately maybe prove a crime, will never qualify as criminal data. And if it is criminal data, Article 10 says that you need a legal basis in the law to process it for blah, blah, blah. And that needs to have specific safeguards, etc. But here, and that's why I think I have a different interpretation of NIS2, etc. It says you need to share intel that may include personal data, and then you need to process it in accordance with the privacy law. It doesn't say if you share it under this law, that is a legal basis under GDPR. Meaning, you need to apply the safeguards, but the legal basis is legitimate interest. And maybe the member states are going to implement it differently, but that is the way they look at it, because it is a legitimate interest. And it already says in the recitals of GDPR that anything you do for cybersecurity purposes is basically a legitimate interest. Anyway, they don't even feel it necessary to say, look, this is not criminal data, because it doesn't qualify as criminal data. Yeah? So this is basically the framework, and I think we overextend it by discussing it in terms of criminal data, etc.
Are there any further questions or remarks? Okay, if not, then we will give all the speakers a chance to just give their final takeaway. We've heard a lot of interesting discussions, also touching upon what actually is personal data? Is personal data being shared when it comes to cybersecurity information? To what extent is it the purpose of cybersecurity information sharing actually a public interest? How to do it in accordance with data protection law. We talked about the lawful basis for processing as well, with the mention of it is a legitimate interest, but also now these different options arising with the newly established legal obligation in a bunch of cybersecurity law. And yeah, many more interesting questions and topics to touch upon. So I will ask all the speakers to briefly, in like 1 or 2 minutes or so, give their main takeaways and also to have a chance to respond to the other speakers. And we will start with Renate. I hope you're still there. Oh, yes, great.
Yeah. So when it comes to all the elements that we discussed in this panel, I'm super grateful for all my colleagues that brought all the different angles of this topic. I'm also happy to learn that indeed maybe the problem is not as big as it seems, although of course we still face that in all these EU laws a lot of exchange of information happens. A lot of threat intel needs to be shared. And there is also, of course, a need for that, given the incidents and the risks and the cyber incidents that happen, and the increase of let's say, digitalization. Now, in that sense, there is still a severe interest, of course, to when it comes to reporting, when it comes to sharing of information, to streamline that. Of course, in all the EU laws that I touched upon in my introduction, of course, harmonization and efforts to share within the different ecosystems is super important. But of course, on a more aggregated level, also an orchestrated approach and a coordinated approach is necessary. In that respect, also there has been interest from several member states, but also from Commission side to say maybe we should more or less also focus on the use of platforms and to more or less synchronize where that is possible. So to reduce all the different exchanges of information and to maybe have a more centralized approach in sharing information where all parties can retrieve their necessary information and make sure that it is shared in an effective way and that indeed whatever personal data may be subject to that sharing is also minimized in that way. So currently ENISA, together with the Commission, but also together in close collaboration with member states, is working on creating such a platform, developing it, and to see whether synchronization to some extent is possible. So this hopefully also brings it to a next level when we come to a lot of information sharing between the different actors.
Thank you, Renate. Over to Niovi.
Yeah, first of all, if I wasn't very clear, I do agree that the primary legal basis is legitimate interest. It's just that legal obligation for notification also appears now as another contender plus public interest. That's I just wanted to clarify to make sure that, because I didn't touch much and it may have been misunderstood. What emerged from this panel, at least from my perspective, is that we learned quite a lot, but we also realized that there is lack of clarity. And I think that this is something that needs to be somewhat addressed. And the fact that there is lack of clarity, despite the references to GDPR, to the processing of personal data, we also learned that this may be less the case, or that there are open questions as to whether there is personal data processed or not. So already the fundamental question as to where and whether personal data are exchanged needs to be addressed. And I think that's the most important thing. And after that, it needs to be regulated. And therefore, I would favor a more clarified approach, which appears that may be the future. I understand that this field is still in development, and therefore, it may not be as clear and we need to round up its edges, but I think this is an important edge that needs to be rounded.
Thank you. Over to you.
Yeah, thank you. My conclusive remarks might be a bit pessimistic, I reckon. And I'd like to zoom out from data protection to focus generally on cybersecurity information sharing. In light of the close relationship between national security, critical infrastructure protection, and cybersecurity, I think that cybersecurity information sharing, the flow of such information in the European space can be significantly hindered by restrictions imposed by member states exercising their sovereign prerogatives, powers, especially vis-à-vis the protection of national security interests, as contemplated also by the treaties of the EU, particularly Article 4, Paragraph 2 of the TEU. And this scenario is actually contemplated also by Article 346 of the TFEU, according to which no European member state shall be obliged to supply information the disclosure of which considers contrary to the essential interest of its security. And these times I observe that more and more member states are pivoting on national security's prerogatives, especially in the domain of cybersecurity governance, to reshape obligations, rules, mechanisms, also of cooperation, and the victim here can be cybersecurity information sharing, albeit last strategies and legal text at the EU level stress its importance. Thank you.
Thank you, and over to Locke.
Yes, well, you know, we get new laws, and I think a lot of this information sharing was taking place for a long time, and suddenly, I mean, cyber is there also for a long time. And suddenly we get new laws, and then there's a debate that things that happen already for a very long time, whether they are allowed or not. And I think it would help if the EDPB would just really boil down what it is about, the different categories, and then the legal basis, and also how they see the interplay with NIS2. And if ENISA, Renate, is making a platform, and I saw it and I applaud it, because there you can organize confidentiality as well, for the individual actually submitting the threat intel, things like that. So I think that is a good thing, but it would be good to also liaise then with the ADPB to try to implement certain requirements of privacy by design also in the platform. That being said, sometimes new things pop up, and I think in guidance, setting it out, what is and isn't allowed is a good thing.
Okay, thank you very much. I will use this last minute to thank all of the panelists for their wonderful contributions that really helped illuminate this quite complex topic with also questioning how much of a barrier is it actually, how much of a barrier is data protection actually to cybersecurity information sharing, but also this need for further guidance and clarity on some of the key issues that we discussed today. So thank you all for coming, and thank you to the panelists, and now we can all enjoy lunch.